Well, good morning, everyone. Welcome to Beyond the Stamp Real Talk with Deb and Leslie. Before we get started, I need to just state that the Michigan Notary Association is not a legal entity. Leslie and Deb are not lawyers. So the information that we provide is meant to help provide clarity and understanding for your edification. It is not to be taken as legal advice. Now, that being said, we actually do have a lawyer here today who can really tell us how it is in legal terms. Today, we are glad to welcome Jeff Sharp, Esquire. You see him on the screen. His telephone number is also there, and he is graciously um, uh, will take your calls and answer your questions. During this session, please put your questions in the chat. Leslie is going to run the chat. I will run the Zoom, and I'm going to let Jeff introduce himself because I don't know you. Leslie knows you. So we kind of flipped the script today. I'm going to put it on speaker view. And Jeff, please introduce yourself.
Yes. Good morning, everybody. My name is Jeff Sharp. I'm an attorney and I practice primarily in the area of estate planning. And in the realm of estate planning, there is powers of attorney. And I'm sure you're all familiar with powers of attorney or getting more familiar with it as we go. There's a lot of misconceptions with powers of attorney. And I think that's why Leslie and Deborah asked me to come today to speak about that. So Liz didn't like my name for this speech, but I'm going to give it to you anyway. It's you don't have to be on a gurney to need a power of attorney. So from that standpoint, that I think that's one of the misconceptions we have, and we'll come to that in a minute. So what is a power of attorney? And we hear about it all the time in TV, in commercials, and in real life. And I think the first thing we need to do is to define attorney. And when we think of attorney, we think of lawyers, but that's not what attorney means. Attorney actually goes back to the 14th century Middle English. And what it means is one who is appointed to transact business on another's behalf. And that's exactly what a power of attorney is. That's where you're naming somebody to transact some kind of business for you. And it's not just business literally, it's all kinds of things. And in fact, there are several different types of powers of attorney, and some are more prevalent than others. Some of the less prevalent ones are for real estate. You may have someone that needs to do some transaction, whether it's a lease, a purchase, or a sale of property, but they're out of town or they just can't attend the meeting. So they would have a power of attorney that's limited in scope to just that real estate transaction or perhaps transactions. So it's a finite period of time. So that's a fairly common power of attorney. And again, it's limited in scope. Another one is for business and stuff. And I apologize, I'm dodging a cat as we go. But from a business perspective, sometimes you're out of town, but there's a business deal you need to transact. And so while you're out of town, you may appoint somebody to transact a specific type of business or a specific job, and it's limited to a period of time. So that's another type of limited power of attorney. Believe it or not, you can use power of attorney to give to somebody your parenting rights. And so we see this sometimes when there's military deployment and someone is deployed out of country, they may appoint a grandparent or another individual to use their parenting rights. And so that is allowed in the state of Michigan. It's actually in the MCL. And so that it's not just for military though. Sometimes, and I've seen this where parents may go on a vacation themselves and leave the kids with grandma and grandpa for a week or two. And so they'll have a power of attorney in case, God forbid, something were to go wrong. So you'll see that one as well. Now, just to give you a heads up on that power of attorney in case you see it, unless it's a military deployment, it's limited in scope to 180 days or less. So that's just one thing to keep in mind. And most people don't go on vacation for 180 days, but I guess stranger things have happened. But if it's military deployment, you need to take over the parenting rights within 30 days of you returning from your deployment. And that's only for deployment overseas. With that in mind, a lot of times what we hear is there's a general durable power of attorney as well. And that's probably most common in the estate planning world. And that's one where we transact business when someone either doesn't want to do it anymore. Typically that's with your elder parents, or perhaps if they can no longer do it because of some sickness or other malady they may have. And coupled with that in estate planning, you see a power of attorney for healthcare. and that's the one about medical decisions. And most people like to have separate powers of attorney. You might see some attorneys that join those together where the financial and the medical are in one document. I like to keep those separate because I don't think that you would want the banks to know what your medical wishes are, and particularly you don't want the hospitals to know what your financial wishes are. So from that standpoint, typically they're different documents. And I think the first three I mentioned didn't mention the word durable, but in the latter two, you hear durable power of attorney for healthcare or general durable power of attorney. And what is durable? And I think that's a very common misconception as well, is what makes a power of attorney durable. So for most powers of attorney, if you don't have the word durable or language accordingly, those actually go away if you become disabled. Durable is what makes it last beyond disability. So you'll see in documents for estate planning purposes, hopefully, a paragraph that talks about durability. And what it says is that this will last through a disability. And that's really what you need to make it work for what it's intended to work for. So from the estate planning world, you're going to want to see durable power of attorney, be it for finances or healthcare. One of the things you see also in documents is, and you may hear this as well, is a springing power of attorney. Springing power of attorney is a document that springs into effect upon a disability. So what does that mean? It's that typically, at least in my documents, people don't want to give up the right to take care of the finances by themselves. They want to maintain the sole right to take care of their finances unless they can no longer do so. So what happens is that you'll see either is two doctors would need to sign off saying they've examined you and they've concluded that in fact you can't take care of the finances. And at that point, that's when the power of attorney comes into effect. And I would say probably 8 out of 10 clients want that. The ones that don't want the immediate power of attorney. And an immediate power of attorney is the document that says I immediately hand over the rights to do so. And I see that with some of my super senior clients where they just are tired and don't want to take care of the bills anymore, or they just want help. And so then maybe they just want the help, and so it's immediately in effect. So I think that's one thing that when you are looking at the documents or notarizing the documents, those are the two distinguishing factors. And if you see perhaps a younger individual, maybe they don't want that immediacy. And so that's one thing that will stand out. If it's older individuals, maybe they want to have the immediacy. So that's a distinguishing factor right there. So with that in mind, when is the power of attorney in effect? I know this is a question that I get sometimes. Really, it's in effect once it's signed. It's in effect, if it's a springing power of attorney, remember, that's the power of attorney that only comes into effect upon disability. The document's still effective. Once you sign it, it's in effect, albeit it's dormant. It's not being put into practice until such time as you're deemed to be disabled. So what I want to take a moment to do is sort of couple all of this together. We've talked about the durability of the power of attorney. We've talked about the springing effect of the power of attorney and when is it effective. So when I sit down with my clients and we do powers of attorney, oftentimes we do a will and a trust with it. But what I talk to them about is probate avoidance. And from that standpoint, there's two parts of probate avoidance. Oftentimes people think a trust, that's how you avoid probate. But it's not just upon your death. You also want to avoid probate during your lifetime. And that's where these powers of attorney come into effect. Because if you don't have a power of attorney, then you're going to the probate court for the guardianship and the conservatorship. Why is that problematic, you ask? Well, it's problematic because you're going to probate court. And I don't know if any of you have experience with the probate court, but what happens is that you need to get in front of a judge and show that there's a need for this document. And you might have siblings fighting over who's in charge. And if that's the case, then it's going to take a lot more time and the maybe hard feelings that linger on. Whereas if you have power of attorney, you're naming who you want to be in that role. And when you name who you want to be in that role, you're giving the order of preference. And so that's who would step in, and you're not going to probate court for that. And one thing you're avoiding also by avoiding probate is you don't need to do the annual reporting requirements. And if any of you had experience with conservatorship, you need to provide an annual accounting to the probate court. Literally what's come in, what's gone out, and pretty much it's got to be to the penny. And I've seen people just all upset spending all these hours because they're off by $3. And sometimes the courts are upset about that $3. Sometimes they let it pass, but if they're upset about that $3, you're trying to find out what happened here. And with the guardianship, that's the guardianship's where you do the day-to-day caretaking, the medical decisions. and they want an annual report. How's mom or dad doing? How is this individual doing? And so you're reporting every single year. So the powers of attorney avoid that. You do not have to go to probate court for those items. So you're avoiding the time, the publicity, and the annual reporting by having these documents. So what I tell my clients when I'm sitting down with an estate planning meeting is that part one of probate avoidance is during your lifetime. And that's where we have the financial and the medical powers of attorney. So when they sign, so when they come back to my meeting, we review and they sign these documents, the documents are effective, they're in place. If it's a springing power of attorney, then it's dormant until it's needed, if it's needed. So it's there, and if something happens, then they get the doctors to sign off and the powers come in. So far, so good? Okay. One
Yeah,
thing to,
that's good. Yeah.
okay.
I'm writing down all these vocabulary words.
Oh, good. There's
Dormant,
a test
springing,
afterward.
durable. Yeah.
Right. So, one of the things that people will often tell me, I don't know if any of you have heard this, but when I talk to them about estate planning, they'll oftentimes say, "Oh, I have powers of attorney, I'm good." But what they don't know is that upon your death, the powers of attorney go away. They're only active during your lifetime. So a lot of times people have the misconception that I've named my son, my daughter, my spouse to be my attorney in fact on the financial end or and the patient advocate. When you pass away, those documents end, and that's when your will, your trust, or any other estate documents come into effect. So they're not all set. So they have to take the next step, which would have some type of plan for what happens upon your death. One thing that many of my clients don't know is that even if you don't do anything, you have an estate plan. And that's because if you don't have any planning of your own, you're leaving it to the state of Michigan to decide what you want to do. That becomes your plan. And that can be problematic because what they think you want oftentimes isn't what you want. And that's particularly true when you have a blended family, when you are not married and have a significant other, a partner, because partners don't have rights in the state of Michigan unless you formalize it through marriage. So I actually have a case right now where there was a partnership for 25 years, and the man is in the hospital, and the daughter not too fond of this partner. So guess who's in charge? Partner doesn't have any rights. So that's one of the big reasons also why you want to have formal documents, be it a power of attorney, a will, or what have you, because that way it gives people that don't have legal rights in the state of Michigan the rights that you want them to have. So that's very important as well. So one question I get all the time, unless there's questions right now, is that I'm oftentimes asked, can the individual who signs the power of attorney still act and take care of their own finances or medical decisions? And again, the answer is yes. You are solely in charge, as under state law, of your medical decisions unless two doctors conclude that you can't take care of your own medical decisions, which makes sense. If you can't make those decisions, you shouldn't be able to. But from the financial side of things, if it's a springing power of attorney, I mean, the answer is no, because it doesn't come into effect until two doctors say you can't handle the finances. But what about my 78-year-old client who named his son to help with the finances, but he wants to do some of it himself? Of course, he can still act unless and until that time where the doctors say he cannot act. So sometimes, like I said, my older clients just want a little bit of help here and there. And that's where they'll have their son or daughter come in and they still pay the monthly bills, maybe, but for some of the more complicated stuff, they have the other people come in, their son, their daughter, what have you, to do so. So, of course, you can still transact business so long as you're capable, as long as you're competent. Unless there's questions about what the sort of the guts of the powers of attorney and some of those things, I want to talk for a few minutes about yes, I'm sorry.
Okay. For those of you who don't know, which is literally everybody but Debbie and Jeff and I, we started we brought Jeff on first as our first guest because I got a question one day, and now I want Jeff to answer it for everybody. Um, if it was from a notary who said that she had to go do a notarization for someone who had given her son power of attorney, and this woman thinks she cannot sign for herself anymore because her son has power of attorney over her. Jeff, is that true or untrue? She was
No,
still
that's
in mind, but she had already signed her estate plan.
twofold. So all lawyers say it depends, but I'm going to say, it's a twofold answer. So of course, like I just mentioned, once you sign something, unless you're rendered incapable by two doctors, you can still take care of what you need to take care of.
Thank you.
So that's a very big thing right there. So I suppose it is a misconception, and if it is, I think, in my opinion, the lawyers did do their job of explaining. But that's neither here nor there. Now, the other side of that as well is these documents are revocable. And what does revocable mean? It can be either revoked or terminated, or it can be changed. So one thing is you're not happy with the way things are going. Again, the caveat: so long as you're capable of making sound decisions, you can revoke these documents. So take an example, your client that maybe named a son to do things. Yes, you can take care of your own matters in business, but if you're not happy with the way the document's working, you can tear it up and start over again or just make changes to it. So that's an important thing for your clients to know, is that these documents aren't permanent from the standpoint that you can never change them. To be fair, there is an irrevocable trust out there, but that's not the scope of this meeting today. And the irrevocable means it can't be changed. But when we're talking about powers of attorney, those things can all be changed.
So the powers of attorney that are within the irrevocable trust can still be changed?
Well, so the powers of attorney are a separate document within that whole plan. So when an irrevocable trust is a trust that can't be changed, we oftentimes see it used from a tax planning standpoint. Sometimes it's used from a special needs standpoint for those with special needs. Those are outside because that's something that handles the money and protects it in the special needs realm from the government taking the money or disqualifying from assistance. From the tax planning realm, it takes the money outside of your taxable estate. So that's more of a death time, or this is not so much a decision making capacity. So when my clients have an irrevocable trust, they will also have separate powers of attorney, oftentimes a revocable trust as well, to handle the money that's not meant to be in the tax avoidance or the special needs world. And from that standpoint, all of those documents are in fact revocable, only the trust itself that's designated irrevocable.
Thank you so much. That is very clear. Thank you. Appreciate that.
Sure. And just one last little asterisk with the irrevocable trust is that most trusts these days have some type of trust protector. So even though we say the trust is irrevocable, if something happens, then there can be a committee of people to make changes. Maybe it's about you've lost all the trustees and need to add another one, or perhaps the laws change, which means you need to update the documents. So there's a little bit of wiggle room from a making changes standpoint, but you can't change, so to speak, the actual guts of the agreement from a distribution standpoint.
Thank you. I appreciate that. Now,
My pleasure.
one follow-up on something you said,
Mhm.
that if it's in probate, they're going to have to, the trustee or whoever it is, executors, has to show where all the money goes. I don't know. I don't know what your words were, but on the notary side of that, this is why we carry receipts, a receipt book, because, and I always offer it when it's a family, when it's a power of attorney, when it's anything, anybody who's like in a nursing home, I always offer a receipt for that purpose right there. They have to show where all the money goes. Back to you, Jeff.
Now I
Yes,
have
just
a
to
question. I go ahead, Jeff, and then I'll
no,
ask my
go ahead.
question.
Please ask the question. I was just going to ramble on.
Oh, okay. So thank you, Leslie. That was a very good point. Um, so who should have a copy of the power of attorney? Like, do you send your power of attorney to the probate court? Do you give it to just your attorney? Do your all of your kids have it? And then second question, if you update or change your power of attorney, is there language in that power of attorney that says this power of attorney supersedes the previous one, so there's no confusion of which one is in effect?
Very good question. So I'm going to start with the latter question. And so I mean, and I probably need to think about this a little bit more. Typically, I just tear up the power of attorney that's the older one. So that's what I typically do. I know in my wills I say it revokes any prior wills, but I haven't done that in the power of attorney, and what happens is that typically when I'm changing a power of attorney, except for like when we had this year with the uniform power of attorney law, I'm not changing the details of what's inside the agreement. It's more just changing the agents and what have you. And as such, I'm seeing the client again, and the more recent in time controls, meaning the newer document controls if there's any inconsistencies. So if the bank had an old one on file and I'm coming with a new document, this is where you guys come in. As long as it's properly executed, witnessed, and notarized, then the bank has to accept it now. So from that, Leslie, what are you doing to me? Is that a yes or a
No,
hooray?
they don't accept it. I just had a client the other day who was like so upset. We did everything properly executed. She took it to Bank of America. No, I'm sorry, it was Comerica, and they rejected it. So
They
she
rejected it. I've not had this happen to me. I'm sorry. You keep
all
saying that.
the time. I really want to talk to somebody at these Comerica, Bank of America, and Chase are the biggest offenders. I keep being told, so Chase has their own power of attorney that they want everybody to sign. So even though they have one with an official estate plan that's made by an attorney, executed by properly, and I'm notarizing it so I know it's done right. I mean, I make mistakes, but I don't make that many mistakes. And they're rejecting it at the banks, and it makes me so angry. And so the ladies, they came back to me and we redid it, and they went back to the bank and they were refusing it again. I said, you have them call me. So I had them call, and the banker was just like, no, we won't accept it. And there was no reason. They had full authority. The one thing they couldn't get, the bank would not give them, was to be able to log into the parent's website or the banking on the website.
Uh,
And uh and they were frustrated. I told them to call their attorney because it was very, very frustrating. And this is continuously, the banks are rejecting it. And I keep giving that copy of the law to them, going, it needs to be accepted, and they won't. So
I hate to say it because I apologize. I have not had that experience. I've always never had that problem. But what it's going to take, because you remember this uniform power of attorney law is supposed to make it mandatory for acceptance.
Mhm.
It's going to take a court case. So
Okay.
someone's going to have to literally fall on the sword, and then once you have a judge saying you have to follow this, then the
Okay.
bank's going to have to fall in line. It's just that who is going to take that, and really what attorney is going to take that leap?
Good question. So if you find it that somebody did, can you just please give it to me so I know the case and I can just tell them
No,
here? I
for
don't,
sure.
I give as much information as I can legally. Like, I will literally print the law out and hand it to them to take to the bank, and they're still not accepting it. And it's so frustrating.
Yeah. So and unfortunately, this law it's not it's been since July, so it's not exactly brand new.
Mhm.
But the banks, unless someone's going to make them do it, they're still going to do what they do. It sounds like now. I again haven't had that experience, but you have on multiple occasions. So I think that if it's happening this often, someone's going to have to take it to the next level. And unfortunately, for most people, they want the path of least resistance. So it's like, oh, I'll fill out your form because I can get it done today, and
And they
that's
do
the problem.
need it right away. Okay, I have another angle that I think we can handle this on. It's not going to be an immediate thing, but we have to do what we can to help people. Um,
Right.
Okay, before you pivot, because this is, look, Heather says hers was rejected too, so it's not just me. Emmett asks a question, and he's like, this is all very good information, both personally and professionally. However, we aren't able to provide direction or opinions on how documents work during the notarization process, so that there's no unauthorized practice of law. So Emmett, we're offering this information so you have it. Um, so that to say, call an attorney or just go, you guys are barking up the wrong tree. But he does ask, what's the best way to transfer this information to our clients so they know the correct information, but legally do it? Like, if he were to become a paralegal, that's a lot of work. Can he still say, this is the answer? Like, what's the best way for us to say that?
Yes. I realize, yeah, the unauthorized practice law is the biggest fear for a lot of you, and it's understandably so. And there's that tightrope that you can walk before you get there. So really what you're worried about really is any liability if you give legal advice. So what happens when you go to the clerks at the courthouse, the probate counter or otherwise, they have posted on the wall, I cannot give legal advice. So I'm going to give you an analogy of what they typically say because I'm there as an attorney, but there's people there that aren't attorneys that are trying to do things for their parents or their loved ones. And so they start asking questions, and what they hear is, I can't give legal advice, but. And so what comes after that but? And oftentimes it's you really need to talk to an attorney, but I would look at this, or I would say I would be concerned about this. So you're giving an opinion, not advice, so to speak, but you're also saying I would talk to an attorney. And then, whether it's me or another attorney out there, you can say this person's an expert. I trust them. And so that would be a good handoff to say. And what I typically say to individuals is you should know enough to be dangerous because that's how you can find the issues, but then you hand it off to the expert.
I like that. I like that, Jeff. That's awesome. And to bring up the point for the people who came in after we started, Jeff's phone number is on the screen so that you can put his information into your phone. If you have someone who does not have an attorney and they're asking you for legal advice and you know you can't give that legal advice, you can give out Jeff's phone number along with his name, and he's more than happy to help. He does give a couple minutes of free advice. He's not going to sit there for an hour and give your customer that. And the good thing about Jeff is he's going to toss it back to you. If your customer calls and says, hey, I talked to Jacob and blah, 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 he's going to help the customer and then he's going to send it back to you. So that's why we like Jeff, because he's very fair and he's very knowledgeable. And I like working with Jeff, just so you know. Okay. Do you have another point, Jeff? Because I've got lots.
I think I missed Deborah's first question when we got into this. And
okay.
so can you repeat that first part of the question, please?
Yes. The first part of my question was, who needs to have this power of attorney? Do you need to make sure that the hospital has it? Does the doctor need to have it? Does it need to go to probate court?
Yes. So my first comment is I would never, ever, ever give it to probate court because it's designed to open or to avoid probate. Remember, that's what the powers of attorney are designed to do. The second part of that is, after we just had this big conversation about banks rejecting it, I mean, I would not give the document, the financial end, to anybody until it's time to use it. I just don't because it's really nobody's business and it could change 2 or 3 times, whether you're changing from springing to immediate or you're changing who's in charge. Maybe you're changing a trust or adding a trust to it and those types of things. Now, that said, if you have a spouse, you're living under the same roof, hopefully. And from that standpoint, then you know where the documents are and where to find them. But if you have, let's say, a child, and I'll use the eldest child because a lot of people think that's what they should do, name the eldest child as the backup. You may want to tell them that, the documents are in the closet or they're here, or here's my attorney's card. If there's an issue, call that person. So that's who I would tell because you don't want them to have an old copy, much like the second point of your second question. You don't want them going to the bank with an older document when there's a new one in hand. And so that's why I don't like to hand out documents. That said, on the medical power of attorney end, I do typically recommend you give it to your primary physician or internist. That way they put it in your chart and it's part of your medical record. And God forbid something were to happen, it's in your medical record already. If you're going to the hospital for some type of procedure or treatment, one of the things they ask you when you are filling out the forms when you first get there is, do you have one? You can also give them a copy of that time and they'll put it right in your file or your chart. And that way it's there, again, God forbid if there's an emergency. Now, from that standpoint, again, you cannot give legal advice. So I just want you to understand that. But I just want to give you an example of my analysis of things. So who is the right person to make these decisions? Sometimes it's not the spouse. If the spouse might have dementia or something, you don't want that spouse in that role. And I'll give you an example. My father had onset dementia and we had to take control away from him. I swear he could not remember my birthday. He could not remember what day of the week it was, but he could remember his Sears credit card going back in time, but he could remember that credit card number. So we went to the mall. I thought it'd be nice to take him out to lunch. Where did dad go? He's ordering tools from Sears with the credit card he had memorized. And this guy had never, ever, ever used tools in his life. But that's kind of what you're dealing with there. So again, that might not be your best decision as to who is in that role. And I just mentioned oldest children. Well, You know, if you have children, you know, every child is different. Some are better at some things and some are worse at some things. So you want to find that person that's just right with the money and can't be too stringent. 'Cause remember, they're taking care of you. You don't want them to be too stringent, but you don't want to be too loose with it either. Now, with the new acceptance of appointment, you know, hopefully they recognize that they're going to be held financially and criminally in the wrong if they do something wrong where they take the money. You know, those made for TV movies, but you still want them to make sure they're taking care of you adequately. I want to take a quick turn to the medical power of attorney. And here's the analogy I use with my clients. If you all remember the Goldilocks and the three bears, is that you don't want someone that's going to pull the plug too quickly. And, you know, I'm not sick yet, but you're pulling the plug. What's going on? But you also don't want the one that's holding on way too long. So you want to find that Goldilocks spot right in the middle where they're going to follow what your wishes are. So just, you know, keep an eye out for that. If you have if you're having a client that's signing these documents, and they're saying, I don't know who I want, or maybe they're going to do this too quickly or something, that's something to keep in mind from that standpoint. So
Thank you,
hopefully,
Jeff. That was very helpful. And so I know, I think Emmett put in there in the chat about, you know, us using this to disseminate legal information, but this is information that we all need anyway. Like for your personal, like in the back of my mind, I'm thinking of my aging parent and what do I need to do? Do we have things in place? Where are her documents located? So like I'm making a list of things that I personally need to check off. So during this call, I'm just saying that to let all the notaries on the call know, like this is information that you need for your own personal selves, not necessarily specifically for your clients. This is good life info for yourself. Thank you, Jeff.
oh,
Please
thank
continue.
you. Thank you. And one thing that I've found is that, you know, it's much easier to talk to your clients about a subject if you've taken care of it yourself. So by having this stuff in the forefront of your mind, you can say, well, when I did it, this is kind of what we looked at. And again, that's not advice, you're giving experience. So that's another way to look at it as well.
I do that a lot. And I was told by another attorney that if I say I'm not an attorney and I don't give legal advice, and then I say, and I'm not telling you this as a notary, I'm telling you this as a mom or as an experience, from my own experience, the disclaimer enough, should be enough, for them to not hold it against me. But I also don't speak unless I know I'm right usually, so there's that too. Um, so yeah. All right, what's your next part? I have two
Well,
more parts for you, just so you know, I'm gonna keep you busy.
no, that's fine. I hopefully I'm hitting these parts right now. So, witnessing and notarizing is one thing I want to talk about. I know that's a big hot topic. So, from a witnessing and notarizing, can you do both? And so, you know, I'm seeing maybe a nod here, a shake of the head there. The answer is, again, a good lawyer answer is maybe. It depends, right? So, what does it depend upon? And really, it comes down to that notarial block. Not notorious, but notarial. So, from that standpoint, yeah, for self-proving wills is a good example. And I know, Leslie, you mentioned that you've seen it on a couple of self-proving powers of attorney, if you will. You know, the big thing to remember is you cannot notarize your own signature.
Can you
So if
describe self-proving? Because not everybody may not understand what that is.
Sure. So self-proving, you know, I'm speaking from the will standpoint, that's a technique which makes it easier to attest to the competency and the proper execution of the will. So you're proving that you are competent and the will is properly executed. Now, what happens is in the witness block, the notary is saying that, you know, the witnesses are here and they're doing everything properly, as well as the testator or the person creating the will. So what that's doing is basically proving the witnesses did their job, they're proper witnesses, and that the person signing the will is competent, capable, and able to make sound decisions. The problem is, if you are notarizing that the witness did their job, can you be the witness in that case? The answer is no, because what does it say under the notary law? Can't witness your own signature. So that's something you need to be careful of what the documents say. And I know that when I first met Leslie, she educated me because I was trying to rapidly go through that and get it signed. She's like, I can't do that. So I found another witness, which is good. I mean, I get educated too sometimes. So, you know, that's where I stay in my lane, you stay in your lane, we'll get along just fine. But you got to be careful. So Leslie had pointed out, and please help clarify if I get this wrong, but you saw a power of attorney where it was also self-proving, so to speak, which you were notarizing the witnesses' signatures, which is something I don't do in my powers of attorney. But in this case, you did, and you cannot witness that power of attorney.
Correct. So witnessing and notarizing have to stay in their own lane unless, so it comes down to read that notarial block. If the notarial block lists the witnesses, you cannot notarize and witness that. It is always best practice to have two separate, but especially when it's new. And so when I get a call and somebody says it's powers of attorney and a will, I ask them to read the notarial block to me or send me a picture of the notarial block so that I can determine if I need two witnesses or one. But I am quickly changing over to you need two witnesses all the time because I have arrived where they say, oh no, it's fine. And then I get there and it's not. So I just started taking two people with me almost all the time, unless it's an attorney that I use all the time. Like Jeff, I've got like 5 or 8 attorneys that we do this all the time. When I know them well and I know what their paperwork is, I know exactly what it is. There are some attorneys, I hear the name, I know automatically I need 2 witnesses because they won't change their notarial block, even though it's not necessary to have the witnesses notarized. They want it, it's their paperwork. They're the ones who have to go to court if needed. I'm just going to go with the flow. So yeah, that is true. Jeff, do you have a website?
Working on it.
Okay, that's what I thought, because I looked it up. Somebody asked for the website, and I'm like, I don't think I've ever seen his website, but hey, there's his phone number. And he's happy to do a one-to-one with you if you have more questions afterwards, but he's not done today. So if you have any questions and you came in late, throw them in the chat. We're more than happy to do that. Somebody does want to know, what's the youngest client you've done these forms for? I know mine is like 22 years old. They did a whole estate plan.
That's a very interesting question. So let me just give you some thing that I think is very important. So what we're talking about is powers of attorney here. So what happens when your child turns 18 typically? A lot of times they go off to school.
Mm-hmm.
So when they go to school, they're now 18, they're adults. Guess what? You don't have any right to what they're doing. So what happens if they get into an accident at school? Something happens. You get a call from the hospital, what's the problem? You can't make decisions for them. You don't have the legal power to do so. So that's where I would say I've done it for 18-year-olds for that very reason. In fact, I would go so far as to say it's responsible for you to have your kids sign a power of attorney, both financial and medical, when they do go away to school. And that way, God forbid, spring break, whatever it might be, something happens to them, you're able to make those decisions on their behalf. And so I have clients that said, I'm not paying your tuition unless and until you sign this document because I need to make sure you're okay if something happens. And I'm going to touch base on that financial one. And please don't judge me on this. I had a friend that took his tuition money and spent it at the bar at Michigan State. So you can imagine, when he went back to dad and said, Dad, I need to pay for tuition, how that phone call went. So, you want to be sure your kids are doing the right thing. And as such, you probably want that financial power of attorney as well. And I would make it immediate, not contingent on disability while they're in school. That way you can access the bank. You can access those records to make sure tuition's getting paid. You're making sure that they're not spending money, let's say, at the casino, things like that. And that's where it's probably a good idea for these 18-year-old college students, young adults, to really have that document in place. Now, that said, I have done for 18-year-olds, but usually when I see my clients typically are in their 30s, have a new family and things like that. So that's probably what I see most often. But the youngest, 18 for sure. That's the youngest you can legally sign these anyway.
And Jeff, you said something that I want to expound on. You said that when they go off to college, if something happens, you can't make decisions for them because they're 18, but the hospital also doesn't necessarily have to communicate the information to you as well because they are an adult. So
That's right.
personally, that happened to me, even though my son didn't go to college outside of the state of Michigan. He was in Dearborn.
Mhm.
So an incident happened, he was in the hospital, and they legally couldn't tell me anything because I didn't have that document in place. So keep that in mind. And then also, this should be show an opportunity for our notaries. Like you can market to people who have high school kids that are graduating that, hey, you need this power of attorney. So those are ads that you can start to get in place for the late summer as they start planning for going off to college.
Hold on, we can't market that they need it. That's giving you.
Well, that you can do that, you can offer that service. I'm sorry,
Yeah,
let me restate that,
yeah.
that you can offer that service. Put the bug in their ear, so to speak.
Right.
There you go.
Make it your experience what I did, and then and so something like that. But I think one of the things is that when you look good to your client, that's when they refer you to others and they keep coming back. So when you're able to give them that sound advice without giving legal advice, that's
Yes.
when they'll feel very confident in you and say, I've got just the person. And frankly, I like being able to say, I've got that person for that, whatever that role might be.
Exactly. Because a lot of people don't know what they don't know. Had
Mm-hmm.
I known that the incident was going to happen, I surely would have had documentation in place. So that you're helping them, um, you're giving them information that they didn't know they needed.
Right,
Yeah.
right. And then being able to speak from experience on both sides. But you're right. I apologize. It's not just for college. I think that's where I see it most often. But for any young adult, so here's my cat. Sorry.
Cats are welcome. It's fine. No worries.
Everyone else is still asleep in my house, so I think she's lonely. So what we were talking about here is, can you sign your own? Can you witness and be a notary? And oftentimes you can't if you're in the notarial block. You need to check and see. But what happens if you don't do your job properly? What is the effect of that? And there's potential liability there. The liability comes out when there's damages caused by your negligence or your misconduct. And so if you are witnessing your signature when you can't, well, that's negligence or misconduct. And so what would be the damages when that does happen? And so I think that, and I was thinking about this last night, and really, I'm not a notary, so I don't have to, ponder, in my head until last night what these damages are. But it's, what if there is a deal that's missed because it was not notarized properly, and so there's damages there? So if you're doing, let's say, that business power of attorney, or real estate power of attorney I mentioned earlier, and it's not properly notarized, and so you lose out in the sale of that $1 million deal or the sale of the house, well, there's some damages there potentially. Or what if you did not properly notarize a document and the wrong person got in place and they're starting doing weird things with it? Then because you didn't do it properly, you could be held for whatever damages they do as well. And it's not just the damages; it's the interest and with that's and growth that really comes along with it. So you need to be very, very careful from that standpoint. I feel like the Godfather right now.
You are.
Right.
And I need our notaries to know that E&O insurance does not cover when you break the law. It only covers when you don't break the law. And you might think, what could I possibly do to use my E&O insurance and when I didn't break the law? So if you notarize your own signature, that's breaking the law. Your E&O insurance will absolutely cover they will provide you an attorney, but you're paying everything back. And whatever damages they assess to you, you're paying. That's not coming from your E&O insurance. We have a notary in our network who is being sued. I will not name names. I am involved, unfortunately, because I referred her. And she did not break the law, but the family found an attorney who took the case, who said, well, it's unprecedented. And I'm laughing because it's unprecedented to sue a notary for what they want. They are suing this notary for allowing the transfer of power to somebody they didn't want to have power of attorney over grandpa. So she has to go to court. She did let her E&O insurance know. She has the whole thing written out. She's got all the proof of everything she needs. She did nothing wrong, but she's going to court. She has to go and defend herself. So her E&O insurance is covering the attorney, and there will be no damages against her. They're going to be sadly informed that it was not the notary's fault, but the family needs to blame somebody, and that's what's happening. So that's when E&O insurance kicks in, that kind of thing, not when you break the law by not knowing. Ignorance of the law is no excuse. Just like when you're driving down the road and you're going 78 and it's a 70-mile-an-hour zone, you are still breaking the law, even though everybody else is doing it. It's still against the law. So just know that when you don't do this, it's on you. That's what he's talking about, the liability. So go ahead.
Well, no, that's all very good questions. So, one bit of housekeeping, that phone number that's on the screen, that's my cell phone, if I didn't mention already. So feel free to text that as well. That way, if I can't immediately answer, I can text back. Just please let me know who I'm talking to, at least the first time, until I can get you entered into my contacts. So from that standpoint, we've touched base on the liability. So thank you for interceding with that as well. And really, even if there's no damages, it's the time and the stress that's involved as well. So it's better to avoid it if you at all can. And we talked a bit about advising the client, and again, we've talked about throughout, and just know enough to be dangerous. I guess issue spotting is the best way to look at it. And so when I am giving seminars like this, I want you to be educated enough where you can find those issues that are out there. And in finding those issues, then you're best suited to say, hey, in my experience, again, the whole legal advice thing, or what I've noticed is this: probably should talk to an attorney because there are other options out there from what my experience tells me. So so from that standpoint, that's probably the best way to approach it. And then from a referral standpoint, like Leslie said, if you were to refer to me, I do hand it back because I found in my business practice, much like you probably do, is that if I refer to somebody else, I'm not getting a referral from you ever again. And vice versa, I'm sure. So, I'd like to set up that network where we can, give co-referrals and things like that. But I'm happy to, again, spend 5 or 10 minutes to answer any questions that are out there and see if there's an actual issue. Um, Unless there's other questions, I know there's one thing. Leslie, do you have the ability to put that on the screen?
I do, but there's something else I want to talk about first,
Please.
even though everybody in the chat wants to talk about the thing that's going to go up on the screen. Okay, so if somebody tells me, hey, I need to sign this document on behalf of my aunt, she needs me to sell her car for her.
Mm-hmm.
Okay, I know by law, I only need to identify the person who's in front of me. But if they're signing as power of attorney, should I see that power of attorney to make sure that they have the agency to act for that thing? Because I know title companies have told us before, and I know people have complained about this online, that title says they have power of attorney, you can go ahead and do it. And then they arrive, the person they have power of attorney over isn't there. The notary has said, I don't feel good about this. I'm going to see that power of attorney because they're like buying or selling real estate, and it's a healthcare power of attorney. And so they really don't have agency to do that. What's the liability on a notary for allowing somebody to sign for someone else when they don't actually have agency?
Well, there's a lot of liability there. I mean, the question is, if you are notarizing for someone that has no authority to sign, what you don't know is that the proper person? And I use this in my estate planning meetings when we talk about this. So nobody wants to pay twice. So, the example is, I use this with my will. So just bear with me, please, for a moment. Is that if you had a bank account in your sole name and you pass away, and so you have one child that comes in the bank says, hey, my mom died, my dad died, please pay me. And then the next day, after the bank pays that first child, the second child comes and says, here's a different will, says pay me. The bank doesn't want to pay twice. And that's the whole probate process. And so from that standpoint, you want to see that document because you don't want to pay twice. And from notarizing, we just got done talking about liability. You're the one that's going to pay the second time because you took away from the family, whether it's an asset or otherwise. So if it's a house, for example, you probably could get the house back because it was done under false pretenses. But there's the expense, the headache, and potential damages from a lost deal, which is all things that could come out of your own pocket, your own reputation, and things like that.
So you're
So,
best
go
case
ahead.
scenario, cover your butt, see the power of attorney to make them show you that they have agency to act on that thing.
Right. And much like when you go to the bank, whether it's, they want to make sure you have that power and they send it to their legal department. It takes a couple days. I'm not saying you just send it to legal, but even some powers of attorney that you might see on the financial end may not cover the power that you are looking to do.
Okay.
So some power, like I said in the earlier, earlier in the meeting, there are limited powers of attorney, which might be just for banking or just for a certain stock trade or something like that, or just real estate.
Yeah.
So what you want to be careful of is if you're doing a deed in the sale of a house, do they have power over real estate? Make sure that that's there. So it's not just, oh, it's a financial power of attorney, we're good. That's not necessarily true.
All right. I appreciate that. Thank you. Because there's so many notaries who say, I'm just notarizing their signature. That's all I'm doing. But you don't know that they have the authority to act on that behalf. And that I wouldn't want to get involved in. Heather says, so you're saying run the POA past the company accepting the document, or we check POA similar to ID?
Okay, so that's a question for me. Okay.
Yeah.
I think that you would need to check the power of attorney yourself because you are notarizing the attorney in fact on that document. So, I if I were in your shoes, I don't think I would care what the company thinks about it. I need to protect myself and be assured that this person is who they say they are, but they also have the power to do what they say they're doing. So from that standpoint, I think the burden's on you.
Okay.
If the company wants to see it, okay, but for your own safety, you need to see it yourself. And
Okay.
that's the right person and the right power.
Right. So Joe says that's interesting. Let's say we requested to see the power of attorney and it looked good to us, but it actually wasn't okay. I am far from an expert on that verbiage.
Excuse me. True. I think that if you are relying upon a document that you have, I think in general you're safe unless you have reason to know that it's not a valid document. And if you do have questions about it, I mean, you're within your right to not notarize or not sign. It may cost you that client, but it may also save you a lot of headache down the road if there are a lot of questions about it. So, if you do have questions, at least until you become more familiarized with documents and whatnot, that sign it if you're comfortable. If not, it's part of the learning process. Don't and go from there.
Yeah.
Um,
What I do is if they say they have power of attorney to do this, I ask them, I want to see the power of attorney. And according to the law that came out in July of last year, it says if it's properly executed, you can assume it's true,
right.
which that's an assumption the law says I can make. I know what proper execution is, and every notary should. But then I ask them to, I don't want to read that paperwork, but I ask them to show me in the document, in that power of attorney, where it gives agency to act on that for that particular matter. And if they can't do that, then we don't do it. Can paralegals give legal advice?
I would not have them do it just because they're not attorneys,
Okay.
lawyers, I should say, because we're talking about powers of attorney.
Okay.
Um, I mean, they're not officers of the court in the same degree that attorneys are. So
Okay.
they're so I they do give legal advice, but they're not authorized to, let's say, do legal things. So
Okay.
they can't stand up in court.
Awesome. And then the other thing, I believe the new law says that a copy of a properly executed power of attorney is as legal as the original. We don't need to see the wet signature, correct?
Correct. Correct. But you need to make sure that's properly. So, I mean, you need to be able to see everything on that copy because sometimes things don't show up on copies. So, I mean, are you safest having an original? Probably, because
Yeah.
you can see everything. But can you still sign if you don't? So long as you're comfortable that it was properly executed, yes, you can do that.
Okay. I know sometimes I go to places and they've got 3 kids, so they want 4 copies of it. And so we notarize 4 copies, which I think is excessive. I don't know. I just do what they ask me to do. I'm not going to say you don't need to have that because that would be giving legal advice. And so I just go with the flow.
Right, right. And like I said, I sign things in duplicate, you know that, but that's so I have a copy and they have a copy. And I'm not a fan of giving everybody copies of documents so they're everywhere. But yeah, everyone has their own routine for things.
Yeah.
I know like and so one of the things, unfortunately, with this new law, is there's gonna be litigation on some things to see how it flushes out unless they modify the law due to complaints. But as you know, a lot of times they're slow in the uptake on these things for changing the law.
Yeah. All right. So I think we got through that. And then for time thing, we're going to move on to that last thing, which I'm going to share my screen. I have to find it. Hold on. And then we will talk about, because I know it was asked a couple times in the chat, like, where do we point people if they can't afford an attorney? So, one of the things that I pointed out to Jeff, and I had to point it out to the State Bar of Michigan. I pointed out to so many people, nobody cares. Well, Jeff can't do anything about it, but State Bar of Michigan doesn't really care. But this, can you all see my screen? Okay, so this is what you get if you go to michigan.gov and you look for a power of attorney. So they give you a whole bunch of them, okay? And I have never read it. I don't really care. It's not, I don't read their documents. I haven't read this, but I do, as you know, when I teach, you do have to read the notarial block. So I go through, they sign, they do all their things, right? And then you get to the notarial block. So they're signing here. And I just had this the other day, and I had two notaries with me who were like, oh my goodness. So we have the witnesses here, the signature of the notary. So this is a sworn to. Not all powers of attorney require an oath, but this one does. The one on the state website. I don't know, Jeff's doesn't, but whatever. But look here, look at the date. Sworn to and signed by, let's just say Jeff Sharp on this 25th day of 2025. What's missing? The month. So this is only going to be valid if you don't put the month, if you don't like put something up in here and write the month. It's only valid in January because in February, the 15th, it's not going to be the 15th day of 2025. So
It'll be the 46th day, Leslie.
What is that?
The 46th day of 2025.
I don't do that. I don't do math. But I just want you guys to know, I have asked the state several times to change this document and they won't do it. So if your people go to the state website to download the paperwork, make sure you fix this in the power of attorney, because the month isn't written there. You have to write it in, or it is an invalid notarization, and that's on you. That's a liability you're putting on yourself by not having a proper notarial block. So make sure you fix that every single time, okay? Does anybody have any questions on that?
So in that case, are we just crossing out, or are we writing above the month?
I put one of those up, like an up arrow, and then I write the month in there.
Yeah, you do a caret.
A caret.
Yeah. Carrots. That's not what it was called in my journalism class, but we'll go with that. So yeah, the other ones are fine from what I've seen, but this one is wrong. Just so you know. Oh, you know what? You want to know what's missing on this also? And you can't, this is so frustrating. Listen, you can give agency all day long, but if no one's accepting agency, it doesn't do any good. I'm not a lawyer, I'm not giving legal advice, but this does not have anyone accepting agency. At the end, there should be a page that says I accept agency, and there's not.
Is it a separate form, or are they just?
No, it's just not there. I'm on page 505. No one's accepting agency on this. See, the principal's signing, the witnesses are signing. They're saying who has agency, but they're not saying I accept agency. That is part of the power of attorney. Jeff, do you want to talk about that while I stop sharing and talk about accepting agency? Because that's pretty important.
Yeah. I mean, we've all seen those made for TV movies where mom and dad have put child on power of attorney, and then the child is all of a sudden in the Bahamas living the good life, spending mom and dad's money. So the way to combat that, because those movies are based off of real life, is they've put appointment acceptance of agency on these documents. And in essence, what that document is saying is that I'm going to follow mom and dad's wishes, and I'm going to act as a fiduciary, and I acknowledge that. If I do something wrong, then I know I could be held criminally or civilly responsible for that. So if I did take the money to the Bahamas, then I would come back and probably be in handcuffs and maybe and repay the money as well. So that's the way that they're combating these elder abuses, I guess is the best way to put it, where they're taking advantage of mom and dad by putting people on specific notice that they will be held criminally and civilly responsible if they abscond with the money. I know in July, that's, they got in even more detail where you don't have these powers unless mom or dad says so. and you will be held responsible for these things. And that's where we have all these boxes we check on the powers of attorney these days for what powers are there. And it's something that has to be signed. Otherwise, they're not validly executed documents, because you need to have that acceptance of appointment prior to you making any decisions on that document. You see it also in the medical power of attorney. There's an acceptance of appointment. So it's in all the various documents that are not valid. The banks won't accept it. The hospitals won't, unless the person making the decision is signing off on that. And from a practical standpoint, I know with documents, I'll have, that for dad, mom signs is the first choice, then son one, daughter, what have you. Oh, I only have the mom sign in that case, and only have the other people sign right before they're to take charge. Otherwise, you'd have 80 pages of documents. But yeah, you have to sign prior to stepping in and making decisions under those documents.
Thank you so much. All right.
Mhm.
Do you have anything else on your list?
My list is complete.
Okay.
I'm happy to answer any questions.
All right. So Emmett is asking if there needs to be a notarization for the agency doc. And that, I believe, is no, in my
No.
experience. It hasn't been, although there are some attorneys who do it, just so you know. There are attorneys who have every last document in the whole entire estate plan notarized. And then there's attorneys who only have the powers of attorney and the will notarized. This is proof positive that there's no law that says anything about anything. And people
Right.
can do what they want. It drives me insane.
Mhm.
The waste. I don't know. It just I go with the flow. And even if it was supposed to be notarized and there's no notarial block, it is against the law for you to tell them that. So we are in a situation where we cannot say go to the state and download this paperwork. When someone calls me and says, I need some powers of attorney, I know you can do that. I say, no, actually I can't, but let me text you the names of a few attorneys. And this literally happened last week. Okay, actually it was earlier this week. I gave 5 attorneys, including Jeff Sharp. I gave 5 attorney names because I don't know who can afford what, and I don't know what anybody charges. Okay, so you get to talk to these people and find out your things. Okay, so I give out all these attorneys, and then they called me back and they said, okay, we're ready. And they brought me the stuff from the state. I cannot tell them that they're not accepting agency. This isn't going to hold up. Like, you're not going to be able to use it. I can't tell them that. It's against the law. All I can do is go there and notarize. I can fix my notarial block, period. So yeah, sad. I gave them the attorneys and they opted to go the easy route, the free route. And this is the kind of thing that happens. Oh, Terry did your notarization. Remember the one out like Wixom Way?
Yes, thank you. I appreciate it. I do remember. Absolutely.
Yeah. Let me look through and make sure I didn't miss any questions.
I actually, can I ask a question going back to what you said
Hi,
about
Evan, how
the,
are you?
hi, good. So when you mentioned that we can obviously not tell them that something's missing off the document, but if we know that the notarial block's missing and we have a notarial block stamp, can we just add that?
You have to ask them if they want it notarized. If they say they want it notarized.
Yes, that's what I'm saying. Like if you're there for a notarization, they've called you, you've set up the appointment, but the document doesn't have that. We can stamp a notarial block onto the document, right?
Well, yes, but how do you know which one? You have to explain the 3 types of notarization.
Right.
And ask them which one they want.
Right.
And if you have the stamp and there's room, yes, you can use that, knowing that the acknowledgement stamp is used in conjunction with your regular stamp.
Right.
It doesn't take the place of it. So you'll stamp the acknowledgement. That's like stamping the notarial block. And
Right.
you stamp your notarial stamp also. So
Yes.
stamps. Yep. But
Yep.
yes, once
Okay.
they establish the type of notarization they want, you can use that if there's room. Yes.
Okay. Thanks.
You can attach a loose certificate if there's no room.
Right. Okay.
Cool. Any other questions? It doesn't look like we've listed, Debbie did link the new law that took effect on July 1st. I want to say it's like page 5. There's 2 parts of there that absolutely you guys should read. Give me a second. I'll let Debbie talk for a second while I bring those up so you can see them.
I saw a question on the screen that I didn't answer yet. I
Okay,
think it
go
was
ahead.
Cheryl that asked, does a will have to be notarized? And so if I may answer that question, although it's outside the scope,
You can.
depends on the type of will.
Exactly.
So I would say, and again, when we talk about what type of will, there's a holographic will, which you can do in your own handwriting. It's got to be in your own handwriting, at least the bulk of it, signed and dated. That does not need to be notarized. But when you don't have documents notarized, you're likely going to be in probate trying to prove that they were validly executed. Whereas your job as a notary is to show that it was in fact validly executed. And that's the whole idea of the self-proving will, is that we don't have to go to court to prove it's been validly executed. So the answer is not necessarily from being notarized, but it should be, and it also depends on which type of will it is.
So I have a question. When we are notarizing wills, should we also emboss them?
It's not legally required. It's nice. I think that it's a good presentation to do so, but unless it's usually I don't have anything embossed unless it's going out of state. So that's just me.
We
Uh,
don't
Okay.
know.
And we don't know if it's going out of state yet.
Well, if they're residents here, you're pretty sure it won't go out of state from the will standpoint.
I have increasingly used my embosser on everything except loan documents. There's a lot of times people call me and say, I can't use you unless you have an embosser. One of our notaries called me last night and she said, I have to do this. And they say they want an embosser and I don't have an embosser. Well, okay, well then refer it to somebody else and get an embosser. Like, it's increasingly people are wanting embossers. So yeah, Emmett, I do the same thing. I have a share here of the new power of attorney law. Jeff, since you're an attorney, I'm going to let you go through this. This is the part about how it's executed. There's another screen too. But parts of this is what you need to know, people, so you know if it is properly executed or not. So Jeff, take it away. Because
Oh boy.
I'm not supposed to interpret the law.
Yes, I know. I'm pinching madly because my eyesight's not what it used to be.
Oh, well, let me read it to you and you can dissect. Or no, you go ahead. I mean, it just says who needs to sign it.
Right. So, basically the principal, that's the person that's signing the document. So, as it says, it's conscious presence. That's always a big thing. Make sure that they're awake and signing what they need to sign, or they can direct somebody. So that's a good question that comes up. Is that Leslie? Please speak from your experience. But can somebody sign for somebody? And the answer is yes, if it's done in front of the witnesses and notary, and that they're otherwise capable of doing so. You can also sign by mark. So that's right.
Yeah.
Right.
So when
go ahead.
so
Sorry.
in the notarial law, the Michigan Law of Notarial Acts, it explains signing by mark. I actually happen to have that right here. It's right here. It is 55.293, persons with physical limitations. So if you have somebody in front of you who needs to sign their will and they can't sign, I don't know. The law doesn't say that we can allow other people to sign. So I don't know why that's in there. That just is whatever. But another individual could be me. And in that case, it says the notary public may sign the name of a person whose physical characteristics limit his or her capacity to sign or make a mark on a record presented for notarization under all of the following conditions. The notary public is orally, verbally, or physically, or through electronic or mechanical means provided by the person and directed by that person to sign that person's name. The person is in the physical presence of the notary, and the notary public inscribes beneath the signature affixed pursuant to Section 33 of the Michigan Notary Public Act. So I personally don't allow a third party to sign any wills or powers of attorney for someone else if I'm there. I will do it. I've got a stamp to put underneath there and they direct it. I'm not going to allow it because who knows who those people are. Yeah, I'm going to sign it now. When we sign it, we're signing their name, writing those words, and then notarizing as usual. I don't I don't. Not that it's up to me. I don't condone like the daughter signing daddy's will. I don't like that. So go ahead. To be durable, the power of attorney signed under subsection 1A must meet one of the following requirements.
Mhm.
Be acknowledged by the principal. Who is the principal?
The signer.
Okay, before a notary public or other individual authorized to take acknowledgements. Who else would be authorized to take an acknowledgement?
Are you asking me?
I am. I don't know that answer.
That it's a big vague gray area, and it's probably, I would say, an officer of the court.
Okay, all right. And be signed in the presence of two witnesses, both of whom also sign the power, subject to both of the following. So both of whom also, oh, so they have to sign this power of attorney. Got it. Okay. Subject to both of the following. A witness may not be an agent nominated in the power, so they can't be the one who's taking agency, correct?
Mm-hmm.
And
Correct.
one of the witnesses may be an individual who also acts in the principal's execution of the power as a notary public or individual authorized to take acknowledgements. So it is saying that you can notarize and witness that document. But the
Correct.
other part of the law still prevails. You cannot notarize your own signature. So with that notarial block cannot list the witnesses if you are signing as a witness. Okay. To be durable, I'm just helping you pinching here, Jeff. To be
Oh, thank you.
durable, a power of attorney signed under subsection 1B must be signed in the presence of two witnesses as described in subsection 2B, regardless of whether the power is acknowledged. What does that mean?
So basically, it's, the witnesses, I guess, do not need to be, and I'm pinching just so I can see it again and just speak adequately here.
It's that last part, regardless of whether the power is
Right.
acknowledged.
Right. So the acknowledgement, that's where you have the officer of the court. It still needs to be notarized, but not necessarily acknowledged by the officer of the court.
Okay.
So that's how I would read it. And I think, because, as Leslie, I think, what you're saying and I'm saying we're in agreement, is that this is not written very well. It leaves lots of questions as to things. So for you all here listening, the best thing that you can do right now is to be safe, which means to make sure that the notarial block is proper so you could witness, or if you're not witnessing, making sure that you have someone that's not named being the witness and things like that. And again, that's the things to be safe. I'm trying to cut your liability down from that standpoint.
Okay. And then it says a signature on a power of attorney is presumed to be genuine if the principal acknowledges the signature before, which means in front of, correct? A notary public or other individual authorized by law to take acknowledgements. Again, we don't know who that is, but it's saying that a signature on a power of attorney is presumed to be genuine if it's notarized. Is that what that's saying?
I see, the way I read that was that they could come to you with, they've pre-signed and said, "Yep, that's me."
Oh, yes, because an acknowledgement, when you're notarizing as an acknowledgement, it can be signed prior to them being there.
Right.
As long as, so an acknowledgement means you're saying you signed it. Okay.
Right.
It doesn't have to be signed while you're watching, but it does have to be notarized while they're watching.
Correct. So you need to make sure that they're saying it is their signature, and that it's everything else is valid from they're doing it voluntarily, competent, all that fun stuff.
Beautiful. Okay. And then it says a signature on a power of attorney that is witnessed as described in subsection 2B, but is not acknowledged by the principal in front of a notary public or individual authorized by law to take acknowledgements, is not entitled to the presumption of genuineness under. So if it's not notarized, it's not, you don't have to accept it.
Right. So, and so the whole purpose of this law is to force the banks to accept this power of attorney, because, as we've talked about earlier in the meeting, that the banks are likely to not. They want their own form. They're trying to be overly conscious of liability on their end, which I understand to a degree. So that's where, if it's notarized and it's properly executed, the banks have to accept it. And we hear that they don't necessarily, and it's going to take the court case. But for sure, if it's not notarized, they don't have to accept it. And that the reason behind that is the witnesses aren't trained like you. So I could go next door to my neighbors who are still drinking their coffee here, sign, can you witness me signing this? They have no idea what's being signed. They have no idea of anything at all. And so from that standpoint, yeah, if I were a bank, I wouldn't accept it either. And that's why we have you guys notarizing these documents to make sure everything's done properly, and that should make it enforceable.
Got it. Okay. Can you see the next slide? It's a 556.206 new validity of power of attorney.
Yes.
Okay. Now we'll go through this part, which also extends to us. And it talks about us deciding if it's real or not. Not just us, but anybody who's accepting it. This is the part that I highlight and give to my clients who have a hard time getting the banks to accept the power of attorney. And it says the power of attorney executed in this state is valid if, when the power was executed, the execution complied with the requirements for the execution of power of attorney under the law of this state as it existed at that time. That kind of covers the old ones that aren't now,
Right.
from prior to July of 2024. A power of attorney that is not executed in this state is valid in this state if, when the power was executed, the execution complied with either of the following: the requirements of the execution of power of attorney under law of the jurisdiction that determines the meaning and effect of the power under section 107, or under law of jurisdiction in which a principal was domiciled at the time of execution. As in, if mom and dad are in West Virginia, they sign all their powers of attorney and they moved here to Michigan, they're still legal, correct? They can still accept those? Is that what that means?
They can still accept those, absolutely, because it's the Constitution of the United States has said that you have to respect your sister state's laws, and so it's just acknowledging that.
Yeah.
So if it was validly executed in another state, it's valid here as well.
Awesome. Thank you. That's what I thought that meant. And then the other one, requirements for a military power of attorney under 10 USC 1044B, which I don't know what those are. I'm sure military has their own things going on. It's way different than when I was a military wife. I have no idea. We didn't even have powers of attorney. It was before HIPAA. And then 3, except as otherwise provided in the power of attorney or by statute other than this act, a photocopy or electronically transmitted copy of an original power of attorney has the same effect as the original. This is the part that people keep going, I need the original. No, you don't. The law says you can take a copy. Am I reading that properly?
You're reading that properly there, and there may be an instance that I can't think of the top of my head where there is a law, maybe it's a securities law or something like that, where they need an original. But
Okay.
absent a law that states that, you're correct, a photocopy is valid as an original.
All right, and that answers one of the questions that was in the chat earlier, so we're gonna stop share. Debbie, Tiff, did you put the law? You did, thank you. I saw that Tiffany was gonna. Section 3 says that the power of attorney hasn't been accepted by the attorney of fact. Is the power of attorney still valid? That's a good question, Heather. So Jeff, in section 3, it's saying that if the power of attorney has not been accepted by the attorney in fact, is the power of attorney still valid?
The document itself is valid, but it's not, as invalidly executed, but it can't be used until somebody signs the acceptance of appointment.
Yeah.
So so that's where you're in trouble if you only have one person on that document you've named as your attorney in fact, because if they won't or can't sign it, then what do you do? But
Right.
if you have backups, my documents say that if someone is unable or unwilling to serve, then you go to the next person. So if someone's unwilling or otherwise unable to sign that acceptance of appointment, you can default to the next person. Hopefully they're willing to do that. And if so, then you have a valid document, valid execution, but now one that's acceptable by the banks.
Right. I have had to go back to the same signer a couple times because, okay, so if you're doing your own estate plan or powers of attorney, please make sure you have, Debbie had mentioned this earlier, have a conversation with the person you want to act on your behalf. I've had at least 3, I might have lost count, people who assumed that their brother, son, daughter would act on their behalf, and they've refused. So we had to go redo the paperwork because they just assumed that these people wanted to act on their behalf. They don't. And I can tell you right now, my son does absolutely not want to act on my behalf, but his wife is more than happy to do that. So make sure you have those conversations. Because especially single people, and it's usually the single people that I have to go back to, because they assume their siblings or their nieces and nephews are going to take care of them. Newsflash, they're not. They don't. You got to have the conversation. Don't just assume.
Always good to have that conversation because you want to make sure that's exactly right, and that's also why you want to have multiple people.
Yeah.
And when you mention your your daughter-in-law, they're probably the ones who want to pull the plug too quickly, so be careful. So,
Right. Right. I don't know who Paper Trail Document Group is, but that person has a question. So maybe we can have a camera and an audio on and we can find out who you are.
Hi, this is Cameron.
Oh, hi,
Cameron,
Cameron.
how you doing?
Good.
Yes,
What's your
my
question?
my question. So right now, I'm actually doing a power attorney, for a family right now. So we getting everything they doing for the brother and the sister. So if one person is not available and they didn't do acknowledgement on the power attorney because they had someone to drawn up the papers. I was just there to notarize for the brother and the sister. Do they have to be filed with when they transfer property and stuff like that? The acknowledgement?
when you say transfer property, we're talking about like real estate.
Yes.
Okay. You would need to have the acknowledgement because that's how you authorize the person to act. They're not authorized to act unless and until they sign that acknowledgement. So that
Right.
would have to be on file, and that, I mean, we could go on for another whole hour lesson about real estate and requirements for powers of attorney and whatnot. But yeah, you need the acknowledgement, whether it's banking or real estate, you need that. And then obviously when you're doing real estate, that's got to all be filed.
Oh,
And so because you need to make sure from a chain of title standpoint that the person properly was able to do this.
okay. Because when I was looking at their paperwork, I'm just a notary. I'm just there to verify the signatures and who's who, witnesses and stuff like that. But I was looking at their paperwork. I was just like, where's the acknowledgement when if, like you said, if one successor is not available, the next one, the brother is the brother and sister that's taking care of both their father and the father's sister. So I
Right.
just set up like, where's the acknowledgement behind the paperwork? I just wanted to know just in case I have to do that for myself. And I was just looking at their paperwork and stuff like that. It was just a question behind my head that I was wondering, like, okay, where is the acknowledgement if they willing to go into like doing the finances and doing the real estate? And everybody's paperwork is different. It just popped in the back of my head when you was talking about who's who if one is not
Right.
available and the other one is not, and or in instance one backs out and the other one is not available or is available. It was just popped in my head.
Yeah,
Just
and
wanted to
remember,
know.
you need to be careful, and that's and so I speaking as attorney, I'm like, hey, you need to do this, but as a notary, it's that whole offering legal advice thing you need to be careful of.
Right.
But so that's where it's hard because I think from what you're saying before, you can notarize the document, you can't say, hey, you need to do this,
Right.
but that's just something you need to be extremely careful about from that standpoint. And then remember this too is that July is when we've had the most recent acknowledgement form, and the acknowledgement form before that was maybe 10 years ago. So it's people still have forms that were created that never had the acknowledgement, or sometimes people pull forms off the internet from a state that doesn't have acknowledgments, or potentially documents that who knows who made those documents you find on the internet. So just you got to
But
be
they had
careful
the
when you're
attorney
pulling
to draw
forms.
these papers up. They had an attorney.
Hmm.
That's why I would just sit up like, wow, okay.
Well,
Well, I can attest to the fact that attorneys don't all know what they're doing. I'm just saying.
Yes,
I've had
completely.
some situations, just so you know. Again, though, all we do is go in and notarize. Don't be reading through their documents. It's
Yeah,
actually against the law. And
right.
offering any advice about what they're signing is against the law. If they had an attorney, the attorney is going to have to defend them in court if they did it wrong. So your job
Right.
to notarize is to, I properly identify, make sure that they know what they're signing and that they're signing of their own free will, period. Your job is
Exactly.
to look through documents, not to compare, not to anything else. So yeah, just don't use that attorney for yourself because clearly they don't know. Jeff's number.
Right. That's why I just
Go there.
question behind my head. I didn't say anything. Like I said, I was there to verify who's who, notarize, and then that was it. Like
Yeah.
I didn't say anything. I'm not going to say anything, but just
Yeah,
keep it moving.
you need to be careful because really attorneys need to specialize and stay in their own lane. And a lot of times if someone comes to an attorney and says, "Hey, can you do this for me?" They're pulling it out of a book or the internet, and they really have no idea the ins and outs. And so that's where we got to be really careful and look for specialties.
Okay. Thank you.
Mm-hmm.
To answer Glory's signature, does signature by mark require the terminology? Yes, it is. It's in section 55.293 of the law. It states it right there for you. If you need a refresher on that, you are more than welcome. If you are a Michigan Notary Association member to take the class a second time, so you can have that in person. It's not what we're covering today, but also, listen, I see that. I read the law, attorneys say no. Listen, I have had attorneys who do not know the law over and over and over and over and over again. So your job is to know your law so you cover your butt. So the law says it. And listen, we've all gone to places where attorneys are like, no, you don't have to. Yes, you do. You have to be strong enough in what your notarial law is to tell the attorney that they're wrong and say, I'm going to cover my butt and walk away. If you're not, there's no amount of money that you can be paid per job that's going to override how much money you're going to spend in court when you do something against the law, because your E&O insurance is not going to cover you. And it's right there in the law, and you can show them the law. I've done it. Jeff and I sat down and talked because I was like, Jeff, I can't do this. And he's like, oh, I didn't know. They don't always know. There's so much law. Not everybody knows everything. The good thing is, if you're willing to learn, if you have an open mind, you can succeed. So if you have had an attorney tell you no, that you don't have to write that under, then don't do that job, or do it anyway and tell them they're wrong. And no witnesses are needed for signature by mark. It depends on you don't need it for signature by mark. You need witnesses for powers of attorney and wills and some other things that some attorneys put it on everything. But not necessarily just for signature by mark. Okay, there's no witness requirement for that. I do suggest you read that. And if you're working for an attorney who thinks otherwise, keep a copy of it on you. I have a copy of the POA law on my phone, and I have a copy of my LONA on my phone, and I am happy to pull it up. I have this dog-eared copy that I say here with, it's right here all the time. And there's one in my bag, and
She's got it memorized.
I got it. You have a question, I'm going to do, and if your attorney still wants to argue, I am happy to have a conversation with that person. You just give them my number. I'm happy to do it. Emmett's.
All right, with that, was there another question in the chat?
Okay, without reading the document, we scan the document with our eyes to make sure everything's notarized properly. My last POA, they missed a signature, and I only found it by flipping through the pages. I don't know where the signature was they missed, but if it was a signature saying option 1, option 2, that's different than the signature executing the whole document. So if it's in the middle, they can go back and change it. You're not there for that. You're there at the end, right above the notarial block. That's your job.
Gotcha. All right, and with that, we are 2 minutes over. So thank you,
question?
everybody, for getting
This
up
is
early.
Robin.
Go ahead, Robin.
So, Leslie, you showed the state of Michigan download for the POA, and it seemed to have some issues with it. And that, to me, it seemed like you probably shouldn't be using that if you really want an accurate POA. So I think someone else asked the question too, where could you direct somebody who doesn't necessarily have the money for a lawyer and stuff like that? If they ask, I know we're not supposed to give all this advice, but I'm just curious too for my own self, because I've done mine through a lawyer and years ago and stuff. I'm just wondering, I have family members that can't afford.
Okay, so it's not our job to navigate their finances. Okay,
I get that part, but I'm just for my own self. This is for me.
Right. And for you, you say it's not my job to navigate your finances. I highly recommend an attorney and give them choices of attorneys. Jeff's number is right there. I keep Jeff's number in my phone and I give it out to a lot of people. How many people call him? Probably 1 in 10. But the point is, you can't solve their problems for them. It is against the law for you to do that. So when they say, I don't know what to do, you say, I don't either. Please ask an attorney. And usually if an attorney talks to a client and they know that they are in like dire, they do not have the money to do this, they will point them in the right direction. They can point them in the right direction. You cannot. Because you listen, if I ever pointed anybody to the state website and said, hey, download this, and then that ends up in probate because it's not properly executed and dad can't sign anymore, and now nobody can sign for him and it has to go through all these other conservators and all that stuff, they can come back on me to say, I told them to go there. I'm not doing that. I give them an attorney and I let them be the adults that they are and make their own decisions.
Can I interject for a quick moment?
Yeah.
Okay. So I just going back to the question, if you are doing this for family that doesn't have the money, likely you're doing it in a role that's not in as a notary. And so if you're doing it as a family member, hopefully the family is not going to sue you for giving advice and say you are the notary. But that said, is that if you're giving that advice, there are legal clinics out there, legal aid type clinics that I don't know which ones, nor do I know where your relatives live off the top. So, but if you do a little bit of research, there is for people without the means clinics that people volunteer their time that can give legal advice. So attorneys will oftentimes do it, and some are on salary there as well. So if it's a simple power of attorney, they very well may be able to do that for them at least a discounted rate, if not free. So I would look to potentially some of those legal clinics to be helpful in those regards. And those are need based typically. So that's where if someone does have the means, they're going to say, no, go see a lawyer. But if they truly don't have the means, that could be a chance for them.
All right, thank you, because I think that was someone else's question too besides mine.
You're welcome.
Yeah. Well, thank you.
Now we're 5 minutes over.
All right. So thank you, everyone, for your questions, for getting up early, for those who were camera ready, for the cat that joined us during the call. We appreciate all of your efforts and your support of Mina. Jeff's number is on the screen, but I'll read it off in case anybody can't see it, 248-910-1207. We are glad to have you in our back pocket as a helpful resource for our notary community. So thank you very much. Thank you, Leslie. And this video will be uploaded into the Mina YouTube group by the end of tomorrow. So thank you again. We look forward to seeing you on the next Beyond the Stamp Real Talk session, which is coming up in, I think, 2 weeks. All right. Have a
Thank
great
you,
day.
everybody.
Thank you.
Thank you. Bye-bye.